My name is Michael Bittoni. I'm an attorney with Callagy Law's New York Medical Revenue Recovery practice. The other day, a client asked me about a verification request they received from an insurance company. They wanted to know all kinds of confidential business information. For example, they wanted to know all of the owners of the practice. They wanted to know if any third parties had any ownership stake. They wanted to know any kinds of business relationships with other medical practices. Generally speaking, insurance companies want this kind of information because they think there might be some kind of impropriety going on either with the patient, with the billing structure, with the practice itself, or some combination of that, maybe even something else. It's really difficult to tell because these requests usually are narrowly tailored for specific information and you have no idea why they want to know this. In general, insurance companies can ask for any information they need to process a claim. When they have a good faith basis to suspect that there's something wrong going on, they can request the kinds of information I just described. But the key there is that they have to have a good faith basis. They also have to articulate their good faith basis when these kinds of requests are challenged. So, if you received a request like this and got a denial because you didn't want to supply that information, first, that's understandable. This is very sensitive information, and you might not want insurance companies to have it. If you still want to deal with the denial, talk to us. These can be complicated situations, and they have to be handled on a case-by-case basis. However, the fact that an insurance company wants to know this from you doesn't mean that it's automatically entitled to get it. Like I said, they have to have a good faith basis. That means the general legal strategy to attack these kinds of requests is to find out whether the insurance company has a good faith basis, and then either attack the credibility of what they believe is a good faith basis, or show that they don't have a good faith basis. Or we can show that they don't have a good faith basis. In some instances, insurance companies will request all kinds of information. Maybe they have a cash flow issue in a certain part of their maybe they have a cash flow issue in a certain part of their business. Maybe there's something else going on. Maybe somebody's new. Who knows? All right. In arbitration and litigation in New York, if a company can't show that it has a good faith basis, then it can't sustain a denial from these kinds of requests. So if you get a request like this from an insurance company, you should call us before the claim is even denied or before it's even processed. These can be alarming requests, and you need guidance. These can be alarming requests, and guidance from somebody who knows the law can help you to handle this in a way that is best for you. Okay. Take a deep breath. Try not to get too nervous. Don't get too scared. Call us. We can help you to understand whether there's any risk at all, and if there is risk, we can help you to mitigate that risk. My name is Michael Bittoni. I work with Callagy Law's New York Medical Revenue Recovery process. You can call us at 201-261-1700, and you can follow us on Facebook, LinkedIn, and Instagram.